God bless you and kingdom blessings. Apostle coming at you. We know that you have been blessed by these teachings that were born out of a sermon that turned into a summit. What was the sermon? It's in the house. And then that went into an awesome summit that we did in the month of February, from his house to your house. Well, we want to let you know that another summit is coming in. But to get you ready for it, we are releasing these awesome teachings from this first summit. We know that you're going to be blessed because everything that we're talking about is all about what you need for your house. Jesus admonished us in Matthew 28:19 to teach them to observe all things. So you're going to be hearing more about investments. You're going to be hearing more about credit repair and debt reduction. All of these things that are making us stronger, so we will have the freedom to be a blessing to the kingdom. So stay tuned now and be blessed by this awesome teaching. God bless.
So welcome each and every one of you to the Wills and Trust session. So let's just relax, take a deep breath and exhale and get ready for this wealth of knowledge that we're about to receive. I know that you have already went to 2 sessions, and I know that you are well pleased with the information that you received. So we're just going to continue on with this session. So first, by show of hands, how many of you either have a will or trust or know the purpose of a will of trust? Okay, so I see by the tabulation that we're really going to learn a lot, and we're just looking forward to that information. So now I would like to introduce you to a very knowledgeable person. Her name is Attorney Rhonda Reed. Attorney Rhonda Reed is the owner of the law office of Rhonda M. Reed. Attorney Reed's goal is to build lifelong legal relationship with each client, one pivotal life moment at a time. Toward that end, she provides general legal services in such areas as estate planning, elder law, probate, and real estate. Attorney Reed has been practicing law for 22 years. Her experience in these areas allows her to both advocate on behalf of her clients and provide wise counsel to assist them in their decision making. Attorney Reed is a member of VKMI and serves in various leadership roles within the church. So without any further ado, I would like to present to some and introduce to others Attorney Rhonda Reed. Thank you.
Hello, everyone. Hello. Thank you, Deborah. Thank you for that introduction, and good afternoon. Isn't this exciting? I mean, I didn't get to go to all the sessions, but this session has been really helpful to people. And I imagine, I agree with Deborah that you all have been blessed by the other sessions. And based on the response here, I see that there's something for us all to learn today. So I'm excited about that. Equally, I'm excited about this technology. Oh my God, we could all get together like this and share the good news. Think of what you could do if you decided to reach out to somebody else, right? We're just so pleased to be here. We're so pleased to have this opportunity to come before you. I am going to talk to you about estate planning essentials. And so that we can all get the most out of this conversation, I would invite you to hit the chat button and put your principal question, the reason you wanted to sit in on this presentation. If you would share that question so that I can make sure I get your question answered along the way, and later we will have an opportunity for you to take the podium and actually ask a question. Maybe you'll hear something that's said, or someone else will raise something up that will cause you to ask a follow-up question. So please take a few minutes here and tell me, what's your principal question, your primary question that you'd like to get answered today? And then Deborah will read those questions out loud, and I'll make note of them, and we'll get started.
The first question is a poor man's will legal?
Okay.
The next one is, what is a transfer upon death document? Does it serve as a will?
All righty.
And someone asked, where do I start?
Very good question.
And another question, how to set up a trust for my kids?
Okay.
Another is, I want to ensure care for, wait, the question moved. I want to ensure care for child when I am no longer able to provide.
All righty.
How do I dissolve structured trust fund? How do I dissolve structured trust fund? Another question. Does it cost to make a will, like LegalZoom?
Okay.
I have another one. Are the free templates for wills available online, legally binding?
Okay.
Okay. Which is better, a video or paper document?
Okay.
Another question. What does a trust do? /for. What is it for?
Mm-hmm.
Where can I go to start my will? And finally, I see, can you determine custody of minor children in a will?
Okay.
I have one more. Do I
Okay.
need a will or trust if I have my daughter and spouse as the beneficiary? Okay.
All righty. So let's get started. These are excellent questions. I was just writing them down, so I make sure, have them organized in some way to make sure I touch upon them. I may not be able to answer every question as in depth as you might like, but we're going to give it a good try. And the point of this presentation is to impress upon you that you need to get counsel. You need wise counsel to make decisions. So, estate planning. The reason I call this session Estate Planning Essentials is because it is essential that we know what we need and that we follow through. The statistic is that over 65% of Americans do not have estate planning documents, a will, or anything else in place in the event of their death. So I would say to you that in the Black and brown community, the percentage is even higher. Why? Because maybe we were never taught to do that. Maybe no one in our family did it or talked to us about doing it. How do you know how to cook? Because somebody took you in the kitchen and showed you what to do, right? How do you know how to repair some things or change the oil on a car? Because somebody did it before you and shared that with you, either at school or in the garage in the back of the house. So maybe you didn't have someone who did that and showed you and impressed upon you the importance of it. That's what we're going to talk about here. There are also reasons that I've heard people say that they don't do estate planning is because they don't figure that they have anything to give. You know, they just feel like they're barely making it now. What do they have to leave? Or maybe they say, I have an only child, so what do I need to arrange? I'm saying to you that you need to have a conversation with an attorney so that you can know that that is actually the truth. There may be some things that you need to have in place that you haven't thought of. I also hear folks saying that they can't afford to do estate planning. They're concerned about the cost of wills and other documents. And I would say to you, what is the cost of not doing it? Because when you do estate planning, then you're putting yourself, you're protecting your beneficiaries, you're ensuring that what you intended to pass along gets to the people that you intended to have it. You are also very possibly minimizing or eliminating family feuds, right? Because 3 different people talk to mama and they got different ideas about what was supposed to happen or what they were supposed to have. I'm sure all of you could probably, you know, if you had the mic, could tell about at least one story where this kind of thing went on, right? That there was a fight. And now folks aren't talking to each other anymore. And folks have hard feelings. And it could have been minimized or possibly totally eliminated had there been the proper estate planning documents in place. So let's get started in talking about what is estate planning and what are the main documents that you might need to have in place. Estate planning is you sitting down, if you're single by yourself, or if you're married with your spouse, and considering what do you have and what do you want to have done with it upon your passing. And what if you become disabled or incapacitated while you're yet living? So estate planning is for death, but it's also for the living. And I can't stress it enough that estate planning is not just for old folks. It's not for the end of your life. I have many clients come in and say, well, I finally got to the point where I need to do this. No, you could be 20 years old and you're on your own. You need an estate plan. And I'm going to discuss with you why you need an estate plan. And I hope that you'll walk away knowing that an adult at any age needs to have an estate plan. Those that tell me when they come to me and they're 65 years old and they say, well, I finally need it, I'm thinking you were just blessed to make it here. That's all. Because we all know someone who didn't. And there was a real, confusion. People went through drama that they would not normally have had to go through. There are 4 main estate planning documents, and you see them listed on the screen. And I'm going to discuss each one of them with you. One of the questions that you asked was, is a poor man's will legal? So what is a will? It was formerly called a last will and testament, but here in Illinois and most states, they just call it a will. And a will is a written document that's been properly executed that tells the world, when I die, it names the person who's supposed to be responsible for carrying out my wishes, and it tells you what to do with my belongings. It's an outright distribution of your assets. In the state of Illinois, a poor man's will is not acceptable. It's not valid. You must have a properly executed will. It cannot be on the back of a brown paper bag and signed by you, and that's that. That was the example they used for us in law school of a poor man's will. It's not properly executed. It doesn't, and even if it was properly executed, The question is, did it attend to everything that it needed to attend to? And I'll give you an example. I have a will that I am going to take to court for probate right now to try to open an estate. The person who is now deceased, that person at the time put in their will specific accounts that named individuals were supposed to receive money from. And over time, those accounts no longer exist. As a result of bankruptcy, she had to close those accounts out. So everyone who's named in that will to receive from that specific pot of money is not going to receive anything under the will because those specific pots of money no longer exist. What's the lesson? Get a will, have a will drafted, have it properly drafted and executed, and then also make sure that you update it every so often. When you have life events that come up, death, marriage, property sold, things of those nature that might change what you are saying in your will. I'll give you another example. I was given a will and I was told that this person now owned this piece of property because the person who had the will prepared and signed the will was now dead. Well, I read the will and I found out that it wasn't properly executed. Matter of fact, the person who was supposed to receive the property was one of the individuals who signed as a witness onto the will. Well, it automatically voided the gift. Even if the rest of the contents of the will could be distributed, that person could never receive the property because it wasn't properly executed. So when folks say, well, can I get something off software, go to these free sites and download a will and things like that? Yes, you can. Yes, you absolutely can. But you get what you pay for. Okay. You have to know that it is going to meet your needs. And most of those services, somewhere in their small print, they say that this is not legal advice and that we have not entered into an attorney-client relationship with you. Basically, do it at your own risk. They've gotten your $49.99 or whatever the fee was, or they've led you to believe that they're there for you, but you don't know that what you have is actually a valid will. Then a power of attorney. I can't express to you how crucial and how important it is for you to have a power of attorney. If you've ever had to call a company and ask to a bank, insurance company, some other financial institution, and say that you want to talk about your mother's information or your father's information, they could be alive or deceased. The first thing you're going to be asked is, who are you? And tell us what authority you have for us to talk to you. And that's exactly what a power of attorney is about. It's about giving someone legal authority, agency, so that they can go and handle business on your behalf with financial institutions under whatever circumstances that you have set forth in your power of attorney. I'm going to share with you my earliest experience with the power of attorney. When I was about 10 or 11 years old, my mom was a very heavy smoker, and she would send me down to the corner liquor store with a note that says, give my daughter a package of cigarettes, Salem 100s in the green box. And I would have $1.25 in my hand, and I would march up to that store and lay it on the counter, and the person behind the counter would turn around and give me the Salem 100s in the green box and take the $1.25, and I would go home. I had power of attorney. I had authority to buy cigarettes. It was illegal, y'all, but I had authority to buy cigarettes for my mother based on that one letter for that one time. That is a limited power of attorney. However, you can have a general power of attorney that gives you that covers far more different parts of your life: banking, selling your property, if you have brokerage accounts, stock accounts, setting up a business, closing a business. It is a powerful document, and you want to make sure that you are giving power of attorney to someone who you find completely trustworthy, and also you believe they can handle whatever things that need to happen, right? Because once you do, you're saying to that financial institution that you're not going to hold them responsible if this person doesn't do the right thing with the funds. Now, for some of us, that may seem challenging, but you need to have friends and you need to have family members or someone you know that's in your life like that. And if you don't have that, you need to develop it. You really do. You can pay for the service as well. But I'm just saying we all need to develop those kind of relationships. We need to be that kind of trustworthy person for somebody so someone can be that trustworthy person for us. A power of attorney says to the financial institution, you can talk to this person and transact business with this person as if you were talking to me. And also in the power of attorney, you can have conditions upon what they can do and when they can do it. So that's really important. The third document is called a medical directive, but at the same time, a medical directive is actually what we call a power of attorney for healthcare. Maybe you've heard that term. And this too is a critical document. The power of attorney for property and the power of attorney for healthcare, those are things that can be used by a 20-year-old. Once, if any of you all have children or grandchildren who are in college, you know that even though you're paying the bill, the university is not giving you their grades, okay? Because they recognize them as adults, and that's an issue of privacy. So with the power of attorney given to you by the person whose privacy or financial affairs would be handled, you're able to get information, take care of things. A medical directive says, I name this person as my agent. And when I'm not able to take care of my own medical, make decisions about my medical care, that I have authorized this person and given them agency. They can decide whether or not to admit me to the hospital, to discharge me. They can look at my medical records. They can approve services, medical treatments, or say no to medical treatments. This is very important. Nowadays, there's a lot of us that are living longer and living by ourselves. Who's the person who can make those decisions? Because if you have a number of people who have difference of opinions, it can be a mess. And I'll give you an example. I was asked to start a guardianship matter. A gentleman, he had, what happened to him? Oh, he fell, he had a stroke, a brain aneurysm. And when he fell to the ground, he was in a vegetative state. His daughter and his son had very different ideas about what was supposed to happen with him. So he was taken and put into the hospital. Then he was transferred to a rehab center. And he never regained consciousness. But they were fighting a legal battle to be the one who decided his medical care and medical treatment. Now, he died after 4 months, but they had spent a lot of money and a lot of anger and angst to try to be the person in charge. It could have been solved by him having a power of attorney for healthcare. He could have named the person who was going to be the one who called the shots, that was going to take care of the business. And the reason that they had to go through that battle was because the more they argued and pulled on the hospital and the nursing home officials, the more they went behind their desk and said, who's legally responsible? We're not getting involved, because they had strong differences of opinion. Then we also have what's called a living will. A living will is a written document to healthcare professionals that says, when I am terminally ill and I am unconscious, this is what I want you to do, or this is what I do not want you to do. And this is something we need to sit down and think about, you all. We travel all over the world. We get on airplanes, we get in our car and we drive to California. We go wherever we want to go. that makes us the possibility that something could happen greater. It's not like 60 years ago where you basically went in your neighborhood and went downtown and came back home. Now we're all over the place. How would it be handled if you were in New York and had a medical incident? You're not there with your normal doctors. Who would they be empowered to talk to? So these are 4 critical documents. They apply whether you're 20 years old, 50 years old, 70 years old. And they're helpful to give in written instructions. You're speaking to people, telling them now, this is how I see it, and this is what I want to happen. Let's see. Yeah. So I want to stop right here. And if there are any questions about what I've discussed so far, related questions, would you please come to the podium and ask your question?
Hi.
Hi.
If you have these wills, like you just talked about, the living will, and something happened to you or something in another state or whatever, and all these documents in place, how do they get this information? How does the doctors in New York get this information if something happened to you?
Okay. Very good question. So once you have your documents prepared, you should be sharing them with the person who you've empowered to take care of your business. They should have a copy of the documents. Now, of course, your local doctors or whatever, you're going to give them a copy. But the person who's supposed to be that agent for you should have a copy of the documents. So when they get the phone call, they know what to do. They know how to carry it out, and they know what to present to the doctors. Yes.
Hi, can you hear me?
Yes, I can.
My question is a transfer upon death document the same or similar to the documents that you have just talked about?
That's an excellent question. A transfer on death instrument in the state of Illinois, what it does is it transfers a piece of property. You're naming, well, it doesn't actually transfer. You're establishing in advance that upon your death, this piece of property will go to the named party or parties in the document. It's recorded with the county recorder's office, and it must happen prior to your death for it to be effective. That's what it is. It only involves a piece of property. There may be other things that you have in a will. You have an art collection. You have fine jewelry. You have, something that you treasure that you want certain individuals to receive. You have cash money, for example, that you might want to give to your sorority, to your church, or something like that. You cannot handle that through a transfer on death instrument.
So if I can just ask, so then on the transfer upon death, which is property, does it include what's in the property?
No.
Or no? Okay.
No, it does not, because it's a deed. It will become a deed. It only includes the property. So you're right. What are we going to do with the refrigerator, the china, the Peloton equipment? No. In the state of Illinois, if you are married, your spouse is automatically the person who can make your medical decisions. They cannot do what the living will does. They cannot, that part which is about end of life, terminal illness, but they are presumed to be the person that can make the medical decisions. Now, how about it? Your spouse is from your second marriage, and you have adult children, and your adult children see it differently than your spouse does. A power of attorney for healthcare will help to sort that out, because otherwise it's assumed that the spouse is the person. If you are not married and you have a medical incident and you're here in the state of Illinois, all of your children have equal voice. How about, like the example I gave, three of them, and they don't see it the same way?
Right.
The advanced power of attorney helps to make it just clear.
If you were on a will and that person passed away, and you have not been able to view the will, but you know that it existed, could your name be taken off of the will? Or how can you find out? How can you find out how you can see the will?
Unless a person files the will with the county office, it's not public, right?
Right.
Now, if the person is still alive, that's one thing. You can ask them for the will. But if the person is deceased, I've had people to call me and say, my mom died 2 years ago. I know there was a will, but nobody's talking and telling me anything. Mm-hmm. Then you can always go into court and file to open a petition against the estate because that person is deceased, and put people in a position where they got to come up and show that there is a will or there's not a will. You can take legal action that will put them in that position, because you're going to name all the people who you believe are heirs and the alike, and they will have to either come up with the will or say that there's no will. In terms of finding out if your name has been removed from the will, no. I mean, if the person is alive, you just ask the person. If they say there's a new will, I've seen instances where there's a new will, and folks will challenge it and say, no, this person wasn't able to make those decisions at that time. Mm-hmm. They were mentally incompetent. They were on 12 different medications and in a nursing home, mm-hmm. and half the time didn't know where they were. How could they have signed a will now? That's exactly. All about challenging the validity of that will, and that has to be a court action. Yes, it can be very costly, and you have to consider the cost before you do something, right?
Yes.
Yeah. Yes. Someone put down here, is a court-ordered guardianship valid after divorce? It depends on who's the guardianship over. I don't have enough information to answer that. And if there was a court-ordered guardianship, the divorce papers should have addressed, in the best scenario, the divorce papers should have addressed what happens. And then it should have gone over to probate court to do whatever is necessary to make that happen. Then someone asked about video or paper documents in terms of wills. Yes, we are now in the electronic age. In the state of Illinois, it's my understanding they still require a paper will, properly executed, but the whole proceeding can be videotaped, and it can, there's situations like, I will tell people, if you have a lot of things that are of value, what I call a monetary value, or even just precious treasures, you can video them just like you would for an insurance claim. Keep pictures of these items so it'll be real apparent which item we are talking about, and that can be added to supplement the will. But to my knowledge, we're here in Illinois, we're not doing video wills at this time. If there's no more questions, I'll go on to the next. How do I get funds that were left in a will, but my name is not on the account? I am the executor. If you are the executor of a will, then you need to, you need to talk to an attorney. If the person who is now deceased and they did not have they have less than $100,000 of assets and they did not own a piece of property, it's very likely that you can get those monies through a small estate affidavit. However, that small estate affidavit has to do with heirs. It does not have to do with friends or what they call legatees, which the will might have just said, I give $10,000 to my best friend, Dorothy. Okay. You cannot use a small estate affidavit for that. If you're in that kind of situation, you're going to have to go to court, open up an estate, petition the court, and be named as the estate representative. Then you can take the necessary paperwork to the bank and you can gather all of the assets of the estate. And then after the necessary probate process, you can receive. And I'll talk about the probate process right now. So if we have these four main documents, we might be thinking, okay, everything's done. No, If you have life insurance, if you have retirement accounts, if you have pension plans, 401ks, 403, whatever, those things do not pass through a will. These things pass by contract. So all of these different instruments have a beneficiary form: primary beneficiary, contingent beneficiary. The point is, make sure your beneficiaries are up to date. My mom was in that situation. Her husband was dying. They'd been together for 12 years. I kept pressing her, saying, who's on the life insurance at work? Who's on the life insurance? She didn't want to talk about it because she didn't want to deal with that he was dying. We finally got there. It was way before Privacy Act things. They knew her. They went in there and they looked at the record and they said, Jimmy, it's not you. Oh, now she's ready to kill him. Okay, now we're going to go to the hospital and she's going to kill the man. So we got the necessary paperwork. We went to the hospital. He really had just forgot to change his beneficiary forms over. The name beneficiary was a woman he had had a relationship with many years before he met my mother. He just forgot. That's why we need to update. He signed the necessary papers to put her as the beneficiary. 4:00 a.m. the next morning, he was dead. Had we not checked the beneficiary forms, had him sign the proper papers to change the beneficiary forms and gotten them back to the business concern in time, that money would have went to someone else rather than to my mother. Check your beneficiary forms. Make sure that they reflect what you want them to reflect. Probate process, again, it's a court-ordered process. If you have no will and you have property or assets over $100,000 and you have a piece of property, your family's going to go through the probate process. If you have a will, your family's going to go through the probate process. And sometimes things will not work out exactly as you may have wanted if your will is not updated and properly put together so that it can be carried out. And I talked about examples of that before. There are informal levels of probate, which is like the transfer on death instrument. And then there is the formal process where it can be supervised by the court or done independently. But do it with an attorney. You have to do the formal with an attorney. I'm told funeral homes are giving out small estate affidavits every day as if they're attorneys, but you need to have wise counsel about what you're doing. That's the bottom line. Another estate planning tool to consider, and that is a trust. A trust is an agreement between the person who had the trust developed, written, is called the grantor, the trustee, and that's usually the same person, but it could be someone different, and the beneficiaries, saying, this is how you're going to take care of things if I become disabled or incapacitated, and this is how you're going to take care of things if I die. Maybe you have a business. Maybe you have more than property, and maybe more than one piece of property. Maybe you have a car and a boat and a whatever, You want to say all of these things I want to put in this container, this vase, and I want them to be dealt with as I specified in this document. To make that work, I can't stress this enough, your trust must be properly funded. Your trust can be 20 pages long, 50 pages long, 100 pages long with specific instructions. But unless it is properly funded, meaning your assets have been retitled, Rhonda Reed, the homeowner, my home would have to say the estate of Rhonda Reed. Then it's in the bucket. If it just says Rhonda Reed, it's in probate land. Okay? Everything that is funding this trust to make those distributions, either outright or over a period of time, to make them happen, it has to be in the bucket. It has to be properly titled. Otherwise, you just have some legalese written out that cost you a lot of money. A trust usually costs 3 to 4 times the amount of a will. However, a will going through probate is going to cost you 2 to 4% of the estate. And the reason people do trusts one reason is because it does not have to go through probate. Anything that's been retitled to the trust doesn't go through probate. The same thing with the land trust, the question about the land trust. If you've put your property in a land trust, it's not going to go through probate. If you've signed over your home in a transfer on death instrument, it's not going through probate. You've made other arrangements for it. Special needs trust. We talk about, I want to make arrangements that things are taken care of for my children. You can have children who are disabled or not disabled. If you have a disabled child, then you need to create a special needs trust, because for them to continue to receive the public funding that's so necessary for them for medical insurance and the alike, they cannot have money come directly to them. It has to be established before they reach like 26, I think it is, and have very specific instructions about who's going to carry it out and how it's going to be spent. You can't pay for medical insurance when the Social Security is paying for it. But you can buy them a television. But you can make sure that when they're enrolled in that special school, that they have the extras. That's how your money is used. You need to consult a lawyer for that. It's very, very detailed, and there are a lot of ways that it can be messed up. If you just have children, minors that you're responsible for, you might do a trust because you want, again, all of those things that have been retitled properly and funding the trust to be spent or issued over time for their education and well-being, for their college education, for their vacations that they take, so that it's done according to the terms of the trust. Again, it can be complicated, but if that's your situation, then that's what you need to do. Someone asked a question about dissolving a structured trust fund. I would say that you need to consult with the attorney who developed it, or the financial institution who is now administering it. I do not have the answer to that question, but those things can be done. And in that trust fund, it speaks to how it can be dissolved. Those are the kinds of things that should be well written out in that trust fund. So a trust is for anything you want to put in it, in the sense of how to take care of me when I am disabled or incapacitated, or how to distribute my estate once I pass, be it either an outright distribution or a overtime distribution. And the benefit is that you don't have to go through the probate process. In Illinois, the probate process minimally takes like 9 months, but it costs 2 to 4% of the estate. You've already paid up front for the trust. Now you have to have a trust administrator, someone who's going to administer the trust. And depending on the size of the trust, you may want a corporate administrator or someone who you know can handle those things accordingly. Two things I want to dispel. I have people come and ask me, I want to trust because I want to make sure that the government or the nursing home cannot get my assets. I want to protect my assets. If your assets are in a revocable living trust, then you still have control over the assets. You cannot protect them from ever being touched by the nursing home or by the government. That is not something that you can do. You have to give things away at least 5 years, 60 months before you are enrolled or make application for Medicaid assistance in a nursing home. So if you can see that 5 years in advance, you do that. Okay. But most of us don't want to give away our stuff. We want to hold on to our stuff. We don't want to give it away, because once you give it away, it belongs to the person that you gave it away to. So there's not really any asset protection unless you are in an irrevocable trust. And that it means that you opened it up, you set up the rules, and you can never touch it and change anything. Someone else is administrating it, and it can never be touched. Normally, someone will have like a $1 million life insurance policy attached to it, something like that. during your lifetime, you can never change it. That's the only way to protect your assets, other than if you own a big corporation and you're going to put some money in those Swiss bank accounts. Let's see. And also, I have lots of folks say, well, I will be protected from creditors, right? Nobody can, this is my get out of jail card. My family won't have to pay creditors. You only own what you have paid for. I don't care in any of these examples of how you transfer your home, transfer on death, will, trust. If there's an outstanding mortgage due on that property, even when they receive it, they've got to deal with the mortgage company to figure out how to pay that mortgage. So you put in place life insurance or something to pay it off, but you don't get away from creditors just because you put things in these instruments. If you're alive, you definitely don't get away from them with the trust because you have control over them yet. You can take them out of the trust and pay your bills. If you're dead, then if it's enough money, they're going to come after whoever took the property. Now, you owe JCPenney's $250. They may or may not track them down. But if you owe somebody enough money to make it worth it, and if it's a secured note on a mortgage, they're coming after you. They're coming after your heirs to make that right. Benefits of a trust: avoid probate, allow you to work some things out while you're still alive for your care if you become disabled, and if you're in the right tax bracket, it can mitigate taxes. Do I have any questions? We have 10 minutes remaining. Any questions of any kind, you can join the podium.
Hello again.
Sure.
I would just like to know, is there a continuous fee for a trust fund, or is there a one-time payment, or, a trust to have a trust fund?
Okay. When you establish a trust, a revocable living trust, then there's a one-time fee. Okay. Now, if you have set it up so that it's administered by a corporation, a bank or something, they may have a fee, an annual fee that they'll charge you to, agree to step up when the time comes. If you have your property in a land trust, there's a registration fee, which is usually nominal, and there's an annual fee, which can also be nominal. Most of them that I've done, it's like $175 a year, to keep that land trust in place, that type of thing. But with a revocable trust, it's a one-time fee.
Okay. Also, one other question. With the transfer of death, and I think Sandra asked before, you said it does not include the items in that home. But if, for instance, you only have one child and the property is theirs, there's no question, there's no issue, right? So I'm saying nobody can do nothing. Okay.
Does a property have to be paid off in order to rename it? No. If you're going to put it into a trust, it doesn't have to be paid off. You just have to work with your mortgage company because they need to know that you're putting it in a trust, and you need their permission to put it in the trust. Yes, there was a will, and was the will probated? Was it taken through the courts?
No, it wasn't.
Okay. So he's not the relative. So what can happen? What can happen is the son of the woman who is deceased. Uh-huh. He can go to the bank with a small estate affidavit and take the money, and if he's right kind of person, give it to your son. Okay. And he's the right kind of person. Yeah, because he's the heir, he's her heir. Yeah. He can say, I'm managing her estate. Okay. Which would be true. And then they ask, who is the money going to? And normally those are heirs. So you say it's going to me 100%. And then he can give it to whoever he wants to give it to. And she didn't name a successor executor.
Well, she did. She named me.
No, she named you as the executor, but she didn't name a person behind you if for some reason you could not or would not serve?
No.
Oh, okay. Because if he was named, then he would be the person. You would just say,
Okay.
"I'm not serving." Okay. It
Okay.
sounds to me like they're depending on how much is in the account.
Mm-hmm.
Depending on how much is in the account, it sounds to me like they want the executor to take the necessary action so that you can be named. A strategy, just a strategy. In next February 2023, it'll be 2 years. Creditor claim period will be over with. Then you could file it and pretty much open it and close it. Otherwise, you're going to file it and open it up, and creditors are going to have a chance to come in and say whether or not she owes them any money. Okay. And so then you have to decide, is it worth opening it up? You know what I'm saying? If you're expecting creditors to come in for the money. Okay. But I'm just saying that. It won't be an open and close situation, but.
All right.
Yeah. No, it sounds like it's going to have to be done. They won't give the money otherwise, so they know that she had a will.
Taxes.
If you're the executor, you're going to open up a probate estate, you're responsible for preserving, keeping everything intact and workable. But if you're not going to do that, you're not responsible. You didn't take on the responsibility to pay the bills or do anything else. But if you are going to go through the process to have the house transferred so that the heirs of the property can get it, then you have a responsibility to do those things. But you also have a claim against the estate to be reimbursed for all your money that you put out of your pocket. Okay. So that you're not just spending your money and getting nothing back.
Is that in every state?
You have to see what the state laws is, but I would imagine that would be in every state, because who would be an executor if they had to pay out of their pocket and not get no money back for all their expense and time? I think we're out of time. I want to thank you all for coming on and allowing me to fill your head with all of this stuff. I hope that this information was helpful to you. Our assistant here is going to put up my email address. And if you have further questions, then, please get in touch.
So thank you, Attorney Rhonda, for that very informative presentation. It was really, really awesome, as were the other two. And the things that stood out with me is a will is an outright distribution that goes through probate, and a trust does not go through probate, and you have the opportunity, or you can have it distributed over time, which is very good to know. Another, never write on a will, because that will void the will. And a third thing is, it is very important to keep your documents updated. And always, I'll say, seek out legal counsel when you're working with legal documents. That is very, very important.
Absolutely.
So, yes. And I want to thank each and every one of you for joining. I hope that you have enjoyed this session as much as I have. It's very informative, and every time I hear something even more important. Right now, you can transition to the lobby where you can visit with the vendors or mingle with other people or network with them. And again, thank you for joining our session. Have a wonderful rest of the day. Bye-bye.
Wow, was that an awesome teaching? Well, you just can't go in the past. We're going to have new classes, and also we're mixing them together in the next summit. You don't want to miss it. Now, there was no charge on the next one, but we want you to put an investment even into your future. So until that time, be blessed, and remember two things. Praise is still what we do, and apostle still here.